Breaking. Nnamdi Kanu has taken a bold step to deal with Tinubu, Omotosho, and the federal government. Welcome to this YouTube channel. In case you are new to this YouTube channel, kindly hit the subscribe bell below because in this channel, I bring you everything that is trending and everything you need to know about Nnamdi Kanu. So the bold step Nnamdi Kanu has taken recently is sending a petition to the foreign mission and international bodies in Nigeria. And in this particular session, I'm here to display the petition Nnamdi Kanu has sent to the foreign mission because it seems Nnamdi Kanu's letter to the NBA was blatantly ignored by those in charge. And even the Sultan of Sokoto recently said that justice is being bought with money, which shows you clearly how Omotosho has been bribed with money by the federal government led by Bola and Tinubu. Because the injustice that has been carried out against Nnamdi Kanu is something that we have never seen in the history of Nigeria before. Because they keep on adjourning Nnamdi Kanu's case and adjourning it and adjourning it and adjourning it. This is 4 years now. Nnamdi Kanu is in detention. His trial has been postponed, has been adjourned on numerous occasions. And here is Nnamdi Kanu now sending a petition to the foreign mission in Nigeria after sending a letter to the NBA. And it is quite unfortunate that the NBA Association of Nigeria have keep on ignoring Nnamdi Kanu despite the injustice being carried out against him in the Federal High Court of this particular country. Without wasting much of time, let's head straight to the content of this petition Nnamdi Kanu has sent to the foreign mission. Because Nnamdi Kanu has told them enough is enough. I won't stay in the DSS detention and keep quiet. I'll take action from the DSS detention. This is what Nnamdi Kanu said through his lawyers. And Nnamdi Kanu's lawyers, Maxwell Akpara and Aloy Ejimako, keep on working to ensure that he's being released. And I commend Aloy Ejimako and Maxwell Akpara for their efforts in making sure that different petitions are sent out. Well, without wasting much of time, let's head straight to this petition Nnamdi Kanu sent to the foreign mission. Mazin Nnamdi Kanu, prisoner of conscience, detained at State Security Services Headquarters, Abuja. Reply: C/O Aloy Ejimako of Council. Dated 22nd of August 2025. And I read the petition header. Petition by Mazin Nnamdi Kanu to foreign missions and international bodies in Nigeria. An urgent appeal for intervention, urging Nigeria to uphold constitutional supremacy, stir decisis, and rule of law. Jointly addressed and copied to the following foreign missions / international bodies in Nigeria, namely United States, United Kingdom, Canada, Germany, France, European Union, Netherlands, Sweden, Amnesty International, Red Cross, African Union, ECOWAS, Scots, Kenya, South Africa, Norway, Denmark, Japan, Brazil, Israel, Finland, and Austria. These were the countries Nnamdi Kanu directed his petitions to, and I read the preamble. I, Mazin Nnamdi Kanu, a dual Nigerian-British citizen and leader of the indigenous people of Biafra, IPOB, write this petition as a captive of the Nigerian states, condemned to unlawful detention and solitary confinement in Nigeria since June 2021. The Nigerian Supreme Court's perverse and unconstitutional ruling on December 15, 2023, in brackets, appeal number SC/CR/136/2022, reversed my lawful discharge and acquittal by the Court of Appeal on October 13, 2022, despite clear jurisdictional nullity and violations of my fundamental rights. By this letter, I respectfully implore your urgent intervention to compel the Nigerian government to adhere to its own laws, respect state decisions, and uphold the constitutional supremacy enshrined in the 1999 Constitution. The Supreme Court's lawlessness, compounded by the Court of Appeal illegal stay of execution, undermines the rule of law, and I seek your assistance to restore justice. Statement of facts. Court of Appeal discharge, in brackets, October 13, 2022. The Court of Appeal discharged and acquitted me, ruling that my 2021 abduction from Kenya, where I entered as a UK citizen, was unlawful, violating the Extradition Acts 2004 and my fair trial rights under Section 36 of the 1999 Constitution. The courts held that my extraordinary rendition constituted a jurisdictional nullity, rendering the Federal High Court proceedings void. Illegal grants of stay of execution, October 28, 2022. And I read, on October 28, 2022, Justice Haruna Simon Samani, JCA, as he then was, leading a panel of the Court of Appeal, granted the federal government's application for a stay of execution of the October 13, 2022 judgments that discharged and acquitted me. This decision is a barbaric and illegal act, wholly unknown to criminal law jurisprudence anywhere in the world. It constitutes constitutional criminality of the highest order, exhibiting a shocking lack of fidelity to the Nigerian Constitution. Nigerian jurisprudence unequivocally prohibits stay of execution in criminal matters, particularly where liberty is at stake. I hold that in criminal proceedings, a stay of execution is alien to our law. The right to liberty is so fundamental, it cannot be postponed. Similarly, Abacha v. State 2022 or 2002, 11 NWLR in brackets PT.779 bracket closed 437 affirms that once a person is discharged, he must be released forthwith. There is no room for negotiation. Liberty cannot be stayed. This illegal stay facilitated my arbitrary detention for 14 months without charge, violating Section 35 of the 1999 Constitution and international human rights standard. Arbitrary detention without charge. October 13, 2022 to December 15, 2023. From October 13, 2022 to December 15, 2023, I was detained for 14 months without any charge, enabled by the Court of Appeal's illegal stay. This violates Section 35 of 4 of Nigeria's 1999 Constitution, prohibiting detention beyond 48 hours without charge. Article 9 of 3 ICCPR, requiring prompt judicial oversight of detention. Article 6 African Charter, prohibiting arbitrary arrests or detention. Ubani V. Director of SSS 1999 11 NWLR in brackets PT 625 129 holding indefinite detention without charge unconstitutional. UN Working Group on Arbitrary Detention Opinion number 10/2018 Zimbabwe affirming that prolonged detention without charge is arbitrary. This detention also breaches Article 5 ECHR liberty and constitutes cruel and inhuman treatment under Article 7 ICCPR and Article 5 African Charter. Supreme Court reversal December 15, 2023. The Supreme Court overturned the acquittal and remitted my case for trial. Despite acknowledging the illegality of my rendition and the trial court's bias, it claimed that the Court of Appeal took its eyes off the ball is a political glitch, not a legal justification, lacking statutory or jurisprudential foundation. The Supreme Court assumed jurisdiction it did not have, undermining constitutional supremacy. Ongoing unlawful detention. I remain detained with my trial pending a no-case submission ruling on October 10, 2025, violating Section 36 of 9 Constitution, prohibiting double jeopardy. Ejiofor V. FRN 2007, affirming that stays of execution are alien in criminal law. Abacha V. States 2002, holding that liberty cannot be stayed post-discharge. Legal arguments. Finality of jurisdictional discharge. The Court of Appeal discharge based on jurisdictional nullity is substantive and final, equivalent to an acquittal. A.G. Lagos State v. Ibokan 2021 16 NWLR in brackets PT.1802 665 at 713 confirms that absent jurisdiction collapses precedents entirely. Abacha v. States 2002 holds that once a person is discharged, he must be released forthwith. The ruling was self-executing from October 13, 2022, rendering subsequent detention unconstitutional. Unconstitutionality of stay of execution in criminal proceedings. The Court of Appeal's October 28, 2022 stay granted by Justice Haruna Simon Samani, JCA, is a flagrant violation of criminal law principles. Ejiofor v. FRN 2007 and Abacha v. State 2002 unequivocally prohibit stay of execution in criminal matters, emphasizing the sanctity of liberty. These illegal acts enabled 14 months of arbitrary detention, contravening Section 35 of the 1999 Constitution. Justice Samani's decision is a profound departure from constitutional fidelity, constituting a barbaric assault on the rule of law that demands international condemnation. Supreme Court's lack of jurisdiction under Section 233 of the Constitution The Supreme Court is limited to questions of law, not retrying facts. In brackets, Ariori v. Elomo, in brackets, again, 1983, 1 SCNLR 1, brackets closed. By overturning a jurisdictional discharge without finding perversity, the Supreme Court acted per incuriam, contradicting Ejiofor v. FRN 2007. And finally, constitutional supremacy and double jeopardy. Section 1 of 1 and 3 establish constitutional supremacy over all authorities. Section 36 of 9 prohibits retrial after acquittal without new evidence. This was Nnamdi Kanu's petition to the US, UK, France, Germany, and other foreign missions in Nigeria. And this is Nnamdi Kanu clearly stating that Nigeria has violated his human rights and also violating the international laws, that the US, UK, France, Germany, and other foreign missions shouldn't keep quiet on the injustice being carried out on him in the Nigerian courts. Well, at this point in time, I'll let you guys think what you feel about this petition Nnamdi Kanu has sent to the US, UK, France, and Germany. What's your thought on this petition, and what action do you think the US, UK, and others should take? Do want to like this video, share this video because it's important, and don't forget to hit the subscribe button below for more trending updates.